Hey, welcome everybody to another episode of Bourbon Bytes. I'm Terry McGraw, your host from Cape Endeavors Incorporated. Today, I am graced by the presence of Zach Terwilliger from Vinson and Elkins law firm. You're a managing partner, Zach? Is that
the DC office, that's right.
The managing partner of the DC office. And so I've invited Zach because he is an expert in all types of law, particularly white-collar crime and white-collar defense thereof, and Vinson and Elkins. So just as a little background, you personally, how did you arrive here? How did you get this specialty? And then give us a little background on Vinson and Elkins.
Sure. Well, great to be with you, Terry. And for all the listeners out there, if they're picking up on some chemistry, it's been great since you and I have been in some foxholes together and actually worked together. So we can speak very openly about this type of work we're going to cover today because we've done it together. You from the cyber side and me from the legal side. My background, I spent the majority of my career in the Department of Justice. Right after law school, I clerked for a federal judge in Miami and then went straight to the U.S. Attorney's Office in the Eastern District of Virginia, which is sort of the eastern half of the state. Big cyber presence because of the dot-com bubble, Tyson's Corner, a lot of cyber work, a lot of military industrial complex in and around the Pentagon. That particular district has the Pentagon, Quantico, Norfolk Naval Base, et cetera, and a large number of government contractors as a result. Spent 7 or 8 years there as a line attorney, spent a year on Capitol Hill working on the Judiciary Committee, then went to Maine Department of Justice headquarters, and worked for the number 2 official, the Deputy Attorney General. I was his chief of staff. Then I became what's called an ADAG, an Associate Deputy Attorney General, who oversaw criminal matters. And then I finished up my government service as what they call the U.S. Attorney, so the presidentially appointed, Senate-confirmed U.S. Attorney for the Eastern District of Virginia. And that's basically the chief law enforcement officer, federal law enforcement officer for that district. That finished up in 2021, and I've been in private practice for about the last 5 years.
So you truly do understand this from both sides of the equation, and you have a very good understanding of how the Department of Justice sort of views all this activity.
I will say, it has been, when you're doing those jobs, it may have been similar for you in your military career. You're like, how is this going to translate? And it has been really interesting to see that all of that knowledge you learn, not just about the law, but the way the system works and the way things are perceived and what is ultimately going to matter to a prosecutor or a supervisor. Yeah, been really helpful in private practice.
Yeah, I can imagine. So I wanted to talk to you a little bit about the Cyber Fraud Act and the associated legal framework around it. It's really been coming up quite a bit, especially for the Department of Defense contractors, Defense Industrial Base, but it also applies, to a greater focus at anybody who has a sort of a government contract. But maybe I'm wrong on that. Does it apply to a greater audience?
Sure.
Can you give us sort of a 30,000 foot view of it?
Yeah, so I think, the way I describe it has certainly there's a cyber component to it, but the False Claims Act. So from the 30,000 foot view, FCA for short, they call it Lincoln's Law because it actually started during the Civil War. Lincoln was sold, as the legend goes, Lincoln was sold some mules that weren't up to snuff, and he was sold rounds allegedly that instead of containing gunpowder just had sawdust. And so they realized they needed a statute to combat fraud on the government. If you're going to be sold shoddy goods to the military, there needs to be some way to go after that. And really, it's a civil enforcement statute, which as a white collar guy and someone who spent his entire career doing criminal work, it's a little bit of a misnomer. It's civil in nature, so it's just monetary penalties. You don't go to jail for violating the Civil False Claims Act. There is a criminal component, but today we'll stick with the civil. And it really is about fraud on the government. It's a false statement to the government. And so at a 30,000 foot level, what you're really looking for as a prosecutor or as a compliance official or as a defense counsel is what was submitted to the government. Was what submitted to the government, was it false? Like, did you say something that was not true? Is it material? Actually would make a difference in whether the contract gets awarded or not. Lots of fights about materiality. And then the last thing is it has to be knowingly. It can't be a mistake. It can't be an accident. You can be reckless and you can be willfully blind. So if you're just recklessly doing something or you're sticking your head in the sand, we call it the ostrich defense, that can apply too. But ultimately, I think the easiest way to think about the False Claims Act is you are going to the government, and you either owe them money, or they owe you money, and what you're submitting and what you're giving them is false. That can be a good that doesn't work. Like we've seen cases where there were bodyguards that were paid a certain government rate, but they had never been taught how to shoot. Okay, well, you gave a deficient good and charged something else. That's a false claim. In the healthcare context, we see it all the time in enforcement actions with upcoding. Like you got procedure A, but you actually submitted a bill for reimbursement from Medicare, Medicaid for Operation C, which pays more money. Or, as we're going to talk about today, you made an affirmative, knowing representation to the government about your cybersecurity and what level it was, and that the government relied on to award you a contract. So I would say that's sort of the 30,000 overview of the False Claims Act.
You mentioned that it's civil with a potential for criminality. But the the bar seems pretty high on meeting what the thresholds for that to actually even be a civil penalty. I mean, what you basically told me is that there has to be willful intent and deliberate statements to misrepresent something to the government. So I guess, should I still be worried about like how it's applied? And I mean,
sure, yeah.
When you say civil versus criminal, does my temperature go down, or I mean, are the teeth to this thing?
It's a really important question, probably really important for your listeners to hear too. So if you ultimately are convicted or settle for the False Claims Act under the False Claims Act, part of what makes it so onerous and scary is you can get treble damages. So let's say you get a contract from the government. Ultimately, the government didn't get the benefit of its bargain because of your false statement, and it cost the damages are $1 million or $5 million, because let's make it a little bit of a bigger number. Well, under the False Claims Act, you can owe the government now $15 million, and so for certain companies, that's a huge amount, obviously. Second is, for each false claim that's submitted, and it's not each contract, it's each claim on that contract. So let's say you have an IDIQ contract and you are just submitting, your bills and you're getting paid. Every one of those, if there's falsity in how the contract came about or how you did it, that can result in a penalty per submission of $14,000 to $28,000. Okay. So massive penalties, like extinction-level events for certain companies. The other part of it is, if you violate the False Claims Act, you can be referred to suspension and debarment and be kicked out of the program. But to your point, it's a knowing requirement, not a willful, and it's a distinction that us lawyers make. Willful, you actually have to know that what the crime is and that you knowingly violated it. You're like, oh, that's a crime and I did it. Knowingly just means like, I know that I submitted this and it wasn't accurate, or I was recklessly indifferent. One of the really tough parts, and I know we're going to talk about this with the False Claims Act, is the investigation itself can cost millions and millions of dollars to comply with, and that's really what you want to avoid, is the investigation. Obviously, you want to avoid a finding, but the investigation itself can take months, years. It can cost millions of dollars to comply with the document requests and the interviews that the government seeks from you. And it can be a major business disruption, and it can cost a lot of money. So you definitely want to make sure your compliance is in order, because you want to be in a position where you are not even being subject to a False Claims Act investigation. And if you are, you want to quickly be able to get to, this is where our documents are, here's our documentation of why we did X, Y, and Z. Like, we're not the company you're looking for.
So I guess, before I go into the question I really want to ask, just based on what you said, I do want to follow up on the civil versus criminal, and when does that switch flip from the DOJ's perspective?
Yeah, it's a great question. We call them parallel proceedings when there's both a civil and a criminal investigation going on. And it usually relates around the egregiousness of the fraud and that knowing and in some cases willful conduct. There's not a bright line. A lot of times it's prosecutorial discretion. Hey, civil's got this. I don't need to get involved. But if the fraud is pervasive, if the fraud involves an entire company, if it's something where this wasn't a lower level person, or it wasn't something that may have been knowingly done, but it wasn't necessarily intentionally done, or whoever submitted the information to the government was a couple angles removed from the chain. There's other statutes too. I mean, if you do something to defraud the government, that could be wire fraud, could be major government fraud. And I think ultimately, at least in my experience, if it's something where a contractor, did something wrong, and it's not completely egregious, it typically stays civil.
And so that's a pretty good segue, though, is that you almost have to have legal representation when you get a CID, right? And so CID stands for
Civil Investigative
Demand. And that is what starts all of the paperwork drill and everything that you do as a subject of the CID has significant ramifications of how you respond. So would you say that this is one of the things where you absolutely have to have legal representation to respond to this correctly?
Yeah, it's interesting. I was thinking about, if we were going to talk through like what are some do's and don'ts, and just to take us one step back, these cases, what makes them really interesting is a lot of these stem from what we call a whistleblower or a relator. And so where most criminal cases start because of an FBI investigation, or you may get a witness or a victim complaint, but generally, it's going to be run by law enforcement. They investigate something, they get a tip, et cetera. A whistleblower is oftentimes someone within the company who has knowledge, who ultimately decides, they feel the need to file a complaint against the company. They file a complaint under seal with the district court. Then they give a copy to the government. So what we call a trial attorney or assistant United States attorney gets like a dossier, a complaint that says, Acme Co. violated the False Claims Act to the tune of, X millions of dollars. I, relator, have this information and it's not publicly disclosed yet. So we want you, DOJ, to investigate and ultimately intervene. And if you intervene and win, I'm entitled to a portion of the recovery. And so
And that's by design.
That's
right?
by design. It's to incentivize people to speak up. Not like it's sort of, you hope everybody would speak up if they saw something wrong. This is to incentivize people to come forward because there's a financial component to it. To your point about the CID, the civil investigative demand, what happens is DOJ gets the complaint, and very rarely do they say, hey, we're not doing anything. They're going to kick the tires on it. And so if you get a whistleblower under seal qui tam complaint filed against you, you're not going to know because it's under seal. But then the next thing that's going to happen is DOJ is going to issue you this document. A lot of you are probably familiar with a subpoena or a grand jury subpoena. This is similar, but it's being issued. It's called a civil investigative demand, and it can ask for documents and it can ask for testimony. And generally, they're very broad. And I have seen CIDs that literally would require the company receiving them to turn over every piece of paper, email, journal, book, record, text message that they generated for a period of 7 years for a company of hundreds of people. I mean, it is. So if you think about that, you in your business know how expensive it can be just to collect, process, host data, let alone review it, let alone produce it. So that's when that CID comes in, that really is the time to call outside counsel to answer your question directly, because you want somebody who can go to the government who's not part of the organization on behalf of the organization, say, what's going on here? Like, what are you really looking at? What is it that you want us to prioritize? Because if you ask for everything, nothing's a priority, and it'll take us 6 years to comply with this. And generally what you try and do is work with the trial attorney on, what do you need first? Can we educate you about this? Because we don't think there's any there. Or what you're talking about was an isolated incident that happened once. Let us explain.
Okay. And so, I guess it's one of those things. You must respond to the CID. Is there a mechanism that says if you don't respond in a certain period of time that you default? I mean, how does that work?
Yeah, great question. So typically the CID will have a very, very short turnaround time, 30 days, 14 days, something like that. And very, very hard to ever respond in that amount of time. So you work with the trial attorney or the AUSA on that. If you ignore it, then what the AUSA or trial attorney do, well, they'll actually go into court and they will file a motion to compel, a motion to like respond. And if you don't respond, then you're now answering to a judge, and then you get the court system involved, and then you're responding, and now this is public record because the motion to compel is out there. So something that was theoretically covert is now over, and you're just going to have to end up responding anyway. So it is one of those where if you're a smaller company and you receive a CID, I mean, it can bankrupt you just trying to respond to it. And that is something where you're absolutely going to want counsel to go and explain, like, this is a tiny company. What you're asking for and what it will cost to do this will make this company no longer an ongoing concern. So,
is there a rubric, given the cost of legal representation and given the stakes that are high, though, is there a point where a company, maybe it's a larger company, it's probably not fair for a smaller company, but a larger company to just say it's easier to just pay the penalty than it is to try to defend against this for 6 years?
Yeah, and that what makes these cases somewhat difficult is, in a criminal case, by the time they've come and filed a charging document against you, you could always plead to what you've been charged with. And so, like, for example, you get charged with armed robbery, like, you have a right to go into court and plead guilty to what you've been charged with. Hopefully you work out a better deal than that and you plead guilty to like accessory or something. But on these cases, what can be frustrating and difficult is the government won't necessarily give you a number at the outset. They need to investigate to a point so then you can get to settlement. And oftentimes that number is really, really high because you haven't had the opportunity to give them all the documents. So it's a great question. It can be a push-pull. One technique, I've certainly used this before, is to go in and say, look, we don't think there's any there. But like, we see this as a nuisance issue and it's going to cost us more to do these document productions. Like, we've seen the other cases, like, what is it that you're thinking here? And you're not going to get there right away. But if you signal like, look, let's not do this the hard way, you can get there. It's those collateral consequences that oftentimes stops people from doing it, whether it's, a suspension and debarment issue, or, the black stain on your company. If you're a public company, is there going to be a shareholder activism suit? Are you going to get sued civilly for this? So unfortunately, it's not like, paying a parking ticket where you're like, well, I didn't see the curb was painted yellow. I can take pictures and go to court and fight it, or I can pay the $40. It doesn't really work that way, but there are ways to short circuit the process and say, look, let's just get to a resolution.
So you almost have to have some type of quality legal representation the minute you get this thing, just to even figure out how to navigate it. Even if the goal was to truncate it, eventually kind of settle for whatever the lesser of the greater evils are, you're still going to need someone with expertise in this area. So I guess I have two questions. How does one identify a firm that is an expert in this? Like, how would I know that Vinson and Elkins, for example, is like the premier firm to do this kind of work?
Yeah, that's a great question. I mean, I think different people go about it different ways. Some of it, if you're a smaller company, you're going to go to the internet and you're going to go to Chambers rankings and see like who are the like ranked attorneys in this space, or you're going to type in False Claims Act CMMC, or False Claims Act Northern Virginia, or False Claims Act DOD, and you'll look and see, oh, this guy's written an article about it. He's done a podcast about it. Like, he clearly knows what's going on. A lot of times, however, you will have a relationship with another general counsel or other folks, and you'll call around and say, hey, like, who did you guys use for this? Or, hey, who would you recommend? Or it can be a situation like with Cape Endeavors, you get called in because, hey, we need some real expert help here. Is there anybody you've ever worked with before? And vice versa. So it happens that way. I mean, we spend a lot of time going out to the market and doing continuing legal education seminars. We spend time writing articles. I think I did 6 different presentations on the False Claims Act in the last 6 months, where we're out there having just this exact conversation and then moving into compliance and what these companies really need to be thinking about, with the idea, obviously, that if there's a problem here, we've come out and explained it to you. You've seen us, you've seen us in person. You've been able to, or virtually, you've been able to lay eyes on us. If you got a problem, like, we can help you. We'll come in and pitch for it. But one of the points you made earlier about representation, you always want, I think, the best lawyers that you can afford. And it's not always that more expensive lawyers are better. I'll be the first to admit that. But in this circumstance, because you're dealing with this treble damages issue and you're dealing with this penalty per claim issue, it is one of those where you investing money on the front end to handle the CID correctly and really get a handle on what's going on can pay huge dividends down the road because the penalties are just so astronomical.
Yeah, I'll bet. And even the legal fee representation, I guess you'll eventually reach an inflection point, but a good quality representation will tell you when you've hit that inflection point as well, right? You'll know well ahead of time that, hey, this is going to be done in 30 days or this is going to be done in 6 years.
Yes.
And so let's approach it that way. As far as the volume, I know we're hearing a lot about it, but have we seen an actual uptick in False Claims Act activity from the DOJ?
It's a great question. So it's typically monitored annually, and we don't necessarily get to see all the numbers behind the curtains, but there's usually a report that comes out and will say this many False Claims Act cases were filed in the last year. And my recollection is like 2024 was a banner year. I think it was like 2.9 billion in recovery. The two numbers you hear a lot in the False Claims Act realm are how many cases were filed and what was the total recovery amount. Because yes, some of that goes to the relator if it's there, but the other goes back to the government. So it's one of those few civil enforcement remedies where you're ferreting out waste, fraud, and abuse, and you're actually putting money back into the government. And so my assumption is there's usually always a slowdown with a change in administration, just personnel, and there can be a hangover in the courts from COVID and things moving through. It can also be a question of how many resources you have to actually investigate the cases and those sorts of things. What I have seen colloquially and what we've seen is there are definitely certain areas of increased emphasis. Now, is that going to result in an overall increase in Ketan cases in 2025? I don't know. Will it result in an overall recovery amount? It's hard to say because one or two massive recoveries can change the whole calculus. But what we are seeing is absolutely attention being paid in the cybersecurity realm. I mean, that is, and look, that's really a basis based on the evolution of NIST 800-171, the CMMC. I mean, this is something now that is being investigated, and you're seeing it. You're seeing those cases highlighted under the cyber fraud initiative. So I do think we can all sit here and say this is a focus of this DOJ, and if you are someone who is involved in controlled unclassified information or classified information, like this is an area you need to focus on.
So that's an interesting point. How does the cyber fraud initiative sort of play into this? Is it separate and distinct? Is it a subcomponent? How do they feed one another, and sort of what is the legal framework around that?
Yeah, I mean, anytime you have an initiative at DOJ, what it really means is prioritization, and sometimes it means resources. Oftentimes, it just means prioritization. So, for example, if you're going to have a civil cyber fraud initiative, what that means is each U.S. Attorney's Office may have a cyber fraud coordinator now. Okay, well, that person now has this role, and that person is going to have to keep track of statistics. Those statistics are going to have to be sent up to headquarters. And it's just human nature that if you're sending in statistics, that's what you're going to focus on and you want to deliver. It also may mean that there's funding reallocation for equipment, personnel, FTEs, full-time equivalent employees. And so the way that's working here, at least the way I see it, is this continued emphasis and prioritization on cyber fraud and the False Claims Act, coupled with NIST 800-171 and CMMC. And you're starting to see subject matter experts within the department and the U.S. Attorney's Office pop up, and they're popping up on case after case after case. So you're building that bench the same way the Eastern District of New York was known for going after the mafia. Now you have certain people who understand this, have figured it out, and are pursuing it. And then as those cases get more and more notoriety and there's more and more press releases, what you're also signaling is, hey, if you're a whistleblower out there, if you're a CISO, you're an IT lead, and this is going on, file your whistleblower complaint. Because look, this guy just, or this person, this woman, this guy just got, $500,000. It kind of feeds on itself. And what you see is it just kind of grows and grows and grows. I mean, you know better than anyone that some of these cybersecurity certifications or scores, like there's a lot of gray there. And it's not black and white, like you gave me sawdust instead of gunpowder, you gave me mules that didn't work. Like you're advancing, like from 2020 to 2025, for example. I mean, the technological advances that took place there, trying to, at least to me, look at technology and cybersecurity in a snapshot is really, really difficult because it's always evolving. And I think that's what's made some of these cases really hard and made it really frustrating for some of my clients and these government contractors, because it's gray.
It boils down, I mean, and I've seen this as an incident response commander, there is often a belief by the executive team that they have done the right thing.
Right.
They believe that all the stuff that they have in place. I mean, they've been paying for it. The CFO's paid for it. The company's paid for it. You hired people to implement it, and there is an honest belief that they think they're good, right? Yeah. And of course, that's where the rubber meets the road. Oftentimes, is that where they think they're good and where they are good can be worlds apart.
Yeah.
And so I guess that. So I guess my final couple questions to you. I know we're pressed for time. How do you prevent falling into this? Is my first question, and the following on. Let's assume you do get one of these. What are the top 3 or 4 things you recommend you do? So top 3 or 4 to prevent it. Top 3 or things to deal with it.
Yeah, I think it's one of those where if you're an established company doing business with the government, this is on your radar screen. So I think it's paying attention to it, investing the right resources in compliance. And if you don't have someone who understands this, reaching out, hiring, a Cape Endeavors or the like is really critical. Bring in that expertise, even on a contract basis, to do a 360 view of, hey, what do you have? Where are we? Like, explain it to us, explain it to our board, explain it to our C-suite. So, investing in compliance. If you're a newer emerging company, I think one of the things that can be difficult is, you want to chase that big contract. Sure, we can do this. And like, if we just land this one contract, we're good to go, especially if maybe you're a small business. And so you can't be that big by the regs. I've seen people fall into that trap. And so I think one of the ways you avoid that is making sure, if you're going to do this work and you're going to get into this work, that you understand what the requirements are, and you hire somebody either permanently or contract, with a Cape Endeavors or someone else to make sure that you understand, what the requirements are. And then I think we talk about this all the time, but culture of compliance is real. And you're a former military man, you've worked in multiple organizations. Like, that if there is not a speak up culture or culture of compliance, like, it can rot from the inside out. This is something you do not want to screw around with. It is going to catch up with you. And because of the KETAM statute, the whistleblower statute, it's not one of those where it's like, well, the government will never find out. You could be sitting across the table from someone who's already keeping book on exactly what's going on. And that's why the whistleblower statute exists. So I think, the way you avoid this is you don't get over your skis too fast. If you don't understand it, you get the help. You invest on the front end. And if you find yourself in a situation where, a contracting officer is saying, like, what's your SPRS score? Hey, we don't see you, in this system yet. Like, this is not something you can ignore. I mean, some of the cases that have been brought actually were people like fabricating a SPRS score and just sort of making up a whole cloth and submitting documents, at least allegedly, submitting documents that like didn't have writing on them. They're like, oh, sure, we'll submit documents. And then if you got a CID or, this shows up at your door, what you really got to do is dig in and figure out a couple things. One is, do we have an ongoing problem? And if we got an ongoing problem, we got to make sure we mitigate it so it's not continuing in perpetuity. And that is, bringing a lawyer in, doing an internal investigation, making sure we understand what happened and making sure it's not happening again may involve reassigning some people, may involve, putting some people on leave, et cetera. The second thing you do is you engage with the government and you engage early to really try and get a sense of what's going on here. Because don't forget, some of these cases are, in my opinion, they can be completely frivolous and brought by a whistleblower. And the complaint sounds really, really good, but it's completely wrong. And so engaging early with the government and explaining, like, I don't know what's in that undersale complaint or what you were told, but like, that's just not accurate. And it's not like any of these other cases you brought. So that's another thing you can do. And then third, I think, is if it is something and you've come in and figured out we do have a problem, making sure you fix it right then and there. What you don't want to do is sort of hope this thing goes away, not invest the resources. And look, it can be a lot. You're talking about hiring a law firm. You're talking about dealing with a CID. Then you're talking about bringing in someone like you to truly fix the problem and make sure, at least in the cyber realm, that we have a system that is going to pass muster, that we have an objective group come in and tell us, no, like, your SPRS score is correct. You do meet these thresholds. You can do these contracts. So I think, if it were me, those are the things where I've seen it go bad. Where we started is, these can be extinction level events for the company. So This is not something to take lightly. This isn't, a suit for, wrongful termination or a suit for, workers' comp. This is a big deal, and it needs to be treated as such.
So I guess we want to leave our audience with sort of a snapshot into the future from where you sit and your expertise. What do you think is coming up in the landscape of compliance, white collar crime? Does the administration have a focus that you can sort of divine from the activity that you see?
Yeah, it's a great question. And oftentimes we are left to just look at cases and maybe pick a line out of a speech. In this case, this Department of Justice, which is frankly somewhat atypical, other than saying, national security and terrorism is our number one priority, they actually gave us a priority list. Back in May, they issued a memo from the criminal division, and granted it's criminal, but says these are our priorities. And really? One of the top priorities they listed was procurement fraud. And we know one of the ways you combat, a major way you combat procurement fraud, is through the False Claims Act and civil enforcement. So we know that is a top priority for them because they've said so. So we know that's on the horizon. I think you can also look at this administration, and if you look at where the Department of Government Efficiency, DOJ, started, that was like an inspector general on steroids. We are going to come in and ferret out waste, fraud, and abuse. So if that's where we started, and as best I can tell, the DOJ is mostly wound down or maybe completely, then these inspector generals who are out there, they're going to continue to run with this ball. And we've heard the president say it. We've heard his cabinet say it. Like, we want to do more with less. We want to, it's not just drain the swamp anymore. It's like, we want to dismantle certain entities within the swamp so that they can't be rebuilt because government had gotten so big. And so it just stands to reason that if your goal is to ferret out waste, fraud, and abuse, do more with less, not raise taxes, but have increase government spending, then if you're going to get rid of the fraud and abuse and the waste, it's going to be through the False Claims Act. The last point I think I'll make on this is you hear a lot from federal law enforcement about, well, FBI is spending this much time on immigration, DEA is doing this, ATF is doing this. And there's a lack of white-collar prosecutors because they've been reassigned to do other things. What makes the False Claims Act really interesting is you have this other group that's initiating these cases. Whistleblowers aren't being furloughed. Whistleblowers aren't being put on immigration cases. Whistleblowers are whistleblowers. And so if they're feeling empowered and they're going to continue to bring cases, that's a pipeline that is not impacted by DOJ's reallocation of resources. So I think one of the reasons we know and will continue to see a lot of KTM cases is that group is private and they haven't been hit. So and whether it's DE&I, cybersecurity, healthcare, there are a number of areas that this administration is focused on looking at. Is anybody cheating or lying to the government? And they take that very seriously. And so that is going to result in more of these investigations and cases.
All right. So do your homework now, be prepared, and make sure you're doing the right thing at all times, which we would imagine should be the go-to ethical response. I actually think this is important to note. It's what you don't know that will bite you in the ass.
Yeah.
And it's or what you make assumptions on. I do think that one of the things I'd like to leave the audience with is it's not okay for your executive team, your boards, who have a fiduciary oversight responsibility, to just not dig into the cyber portions of this. We expect, based on Enron and Sarbanes-Oxley, we have this sort of framework that grew out to do, at least a transparency effort in the financial aspects of publicly traded corporations. But we've never really laid that same focus until very recently on the cyber. And we've seen IP leave. We've seen compromise of our infrastructure. We've seen, we've given advantages to our adversaries based on that. I think it's high time our executives put some key performance metrics around their cybersecurity as well. The government's going that way with 800, 171, CMMC program, the DFARS regulations, et cetera. But given you add all that, then the cyber fraud initiative and the False Claims Act, now you've got a spectrum of things that you really should, as a board and as an executive team, start paying attention to.
Yeah, and with the with now AI increasing exponentially every day, that's a whole new set of risks. It's also a whole new set of potential compliance, because you don't necessarily have to have a body sitting there, as your compliance officer 24/7. You can utilize the technology to help minimize risk, but it also creates a huge risk.
Right.
So I agree.
And the veracity thereof. Right.
Yeah.
So but Zach, I really, really appreciate it.
Great to be with you.
Great with you, as always. I appreciate it. To the audience, I know from firsthand experience, Vinson and Elkins is an exceptional firm. It has exceptional people. I've met a lot of the folks on the team. If you're in this particular predicament, you should do yourself a favor and call the team at Vinson and Elkins, as well as other cyber matters. You guys do the full suite of everything, white collar crime defense to cyber matters, and all of that. Is there an area that you're not, that we shouldn't go to Vinson Elkins, or pretty much if you need it, you go to
VNA? Come to us. Yeah, absolutely. And right back at you. As we started out by saying, having actually worked with you in the trenches and your team, there's a lot of people out there doing this work, but the responsiveness and you and I, as you know, from these incidents, you're on the phone, 12 hours a day, all manner, especially in the early days, and being in the foxhole with you was just tremendous.
Absolutely. Likewise.
Yeah.
Zach,
thanks a lot.
Appreciate it, brother.
Yeah.